For a corporate joint venture, there are only two ways to end a corporate joint venture, and that is either to liquidate the company, pay its debts, and distribute the balance to the partners, or to sell it. And you will often see in corporate joint venture documentation provisions which deal with the eventual sale of the company. You may have options or other arrangements that actually require a sale after a period of time. But if you're trying to negotiate these particular requirements in a corporate joint venture, they do need to be agreed. A share in a company is a personal property right. Only in very limited circumstances can a shareholder be compelled by operation of law to sell their shares. And accordingly, if, for example, you're the majority partner and you want to be sure that your minority will sell out with you when you want to exit the whole joint venture, you will need to specifically provide for that in your contract. In order to achieve a liquidation, I mentioned the voting requirements you can see on the screen. A 75% majority of the shareholders is required to commence the liquidation process. So again, if there is some protection for minorities in those circumstances. The structures for joint ventures that I've been talking about are set in the context of the general rules in Europe relating to contracts, and in particular some EU conventions that deal with choice of law and enforcement of judgments across Europe. It's perhaps important, by way of background, to understand that there are different rules in different jurisdictions in Europe dealing with contracts and partnership and joint ventures, and it's important to understand what your starting point is. If you like, if your starting point is England, you want to establish your joint venture in England. Generally speaking, there are no implied rules for contracts. There is no law which implies a relationship between the parties. So, in other words, the contract has to state everything that the parties wish to achieve. In Germany, you do get implied rules in relation to contracts, for example. And one of the important ones that we cover when we're assisting on joint ventures in Germany is that a judge or a court in Germany has far greater leeway to interpret a contract. If there is a gap in a contract, a court in Germany may be able to fill that gap in accordance with what they believe to be the reasonable intention of the parties. So when you start your joint venture, understanding the legal and contractual background to your joint venture is very important, because it will certainly set the scene for how you approach the drafting and the construction of contracts once you start negotiations. The EU conventions which I mentioned are designed to assist. Often business people will be very focused on the commercial terms of their negotiation and not think about what is the proper law of the contract that they are signing. So if you get an international joint venture, perhaps between a Finnish, a French and a British party, there'll be a contract that they make. It clearly governs rights and obligations across different countries in Europe, and the question then arises, which law governs that particular contract? Well, EU conventions are designed to assist that, and equally they also will give you a general rule as to where to enforce the contracts, and indeed also provide for the mutual enforcement of judgments across Europe, so that if you get a judgment in one European member state, you don't have to start again in the member state where you wish to enforce with a new court proceeding. The general rule on proper law is that the law which governs the contract will be the law which has the closest and most real connection to the contract in question. And jurisdiction, if you have to sue somebody, the jurisdiction that you will be suing in is, generally speaking, the seat or registered office of the person to be sued. I mentioned there the last point, a point on mandatory domestic law. There are some provisions which apply regardless of the contract that you sign. The easiest one to identify relates to corporations. You can have A joint venture agreement, if you like, an agreement between shareholders, or a voting agreement governed by any law that you choose, a contractual agreement, and you can certainly within the EU choose a contract, choose a law which is sensible for that purpose. But as soon as you start to apply that contract to, for example, acquire shares in the local company, or to wind up the local company, then mandatory rules will apply, and you will be obliged then, if it's an English company, to come to England to deal with English rules on return of capital, or transfer of shares, or Finland or Germany, wherever it may be. So your joint venture agreement always needs to take account of the fact that there will be some mandatory provisions of domestic law which you have to take account of. Now, I've taken a fairly high level approach here. I hope that's been the right approach for this audience. But even so, there's still quite a lot to digest if you're not used to international joint ventures. I can only recommend that the way to approach any consideration of a joint venture is to start with your commercial objectives. Understand as a commercial matter what it is you're trying to achieve and what the components are for that success. What resources you will need, who needs to supply them. Really break it down into these commercial basics. And once you have got that clear, then it is much easier to establish whether you need a particular type of joint venture and what the legal implications of your arrangements will be. I think in terms of lessons from the past, one point I would say is that the joint venture agreements, the legal agreements, should be confirming a relationship between parties that exists rather than establishing a relationship. It's perhaps a criticism of some people that they will approach negotiations in a very legalistic way and essentially try and impose the relationship of parties out of the legal process. I don't really recommend that approach. I think the contract is important as it establishes the rights and obligations between the parties. But first and foremost, there must be a good relationship between the parties. The joint venture agreement complements that relationship. It does not establish that relationship. So far, I've said nothing about tax. Tax is clearly an important aspect in any joint venture. This is not intended to be a talk on tax. The taxation of joint ventures requires some care. It's not just a matter of how the parties are taxed once they participate in a joint venture. It is very much about the taxation of the profits of the joint venture vehicle, whether it's the partnership or whether it's the new corporate, and in particular how the income that is derived from a joint venture is taxed. The taxation of dividends, the taxation of interest, the taxation of supplies or royalties. These all require separate consideration when you're establishing your joint venture. Well, I hope that's helpful. I think that's my time, and I look forward to questions later on.